Good evening, this is John Milburn for Laws 12066 Land Law. We're into week 5. This week we're dealing with co-ownership. Co-ownership, is it the easiest week that we will have in land law? Maybe. What types of co-ownership exist in Queensland? A couple of easy questions to warm you up. You can unmute your microphone. You can use the chat facility. Joint tenants is one. Joint tenants, yes. Who was there? Did someone want to say something? Tenants in common. All right. So we have the two. And the rule of survivorship, or the law of survivorship, or the right to survivorship, whatever you want to call it, where does that apply? In which one? Joint tenancy. Joint tenancy. And if you wish to have property owned in unequal shares, which one would you choose? Joint tenancy or tenancy in common? Tenancy in common. Easy. Okay, folks, well, that's all we need to do about co-ownership. So thank you for joining us this evening. Simple, hey? Or is it? Is there a little bit more to it than that? What you have said is entirely correct. And for the most part, almost always, that's really what you need to know. But there is a bit more to it. Before we go into some of those details, a quick note about the examination. I have received the draft timetable, which is available to staff. I'm aware of the draft date. I'm not allowed to give you that date, but I am encouraged to tell you to visit your My Centre student account for further information. If I receive advice that the exam timetable is out, formally I'll let you know, but please monitor that. And one of the things I'm told is that there may be slight discrepancies for individuals. If you have any concerns about being able to sit the examination, please contact the exam centre and have a chat with them about that. Another thing is that whilst originally I had intended the examination to be for a duration of 2 hours, I've changed my mind and I'm going to make it 3 hours. Now, I'm not sure if that's good or bad. Previously, thinking that I was helping everyone in subjects, I would make them 2 hours exams, and then people would say it's too tough, it's too hard. So you've got 3 hours. All right. Monique says it has been released. So Monique, what date did you receive advice of the examination?
It's the Friday at the very start of exam block. I think it's the 12th.
Yes, I was told it was the 12th. So thank you for letting us know that. 12th at 2 p.m, 3 hours. Now, I've got to be careful here. That is the standard block, but your individual circumstances may, for whatever reason, change. So please verify that by looking at the My Centre student account records. Karen says, and then a quiet drink afterwards. All right. When I went to university, Queensland, in the 70s and the early 80s, there were two types of people. There were the regatta people and there were the Royal Exchange people. And I'm sure you know which one I was. All right. So, Property Law Act, 1974, Part 5. No one's voting whether I was regatta or RE. Deals with concurrent interests in co-ownership. Leonie was both. Oh, you're a rare breed, Leonie, to be both. Division 1 deals with general rules. Division 2 deals with statutory trusts, sale and division of co-owned property. Section 37 deals with the definitions of co-owner and co-ownership. What's interesting to me about the definition of co-ownership is a phrase in the middle of the definition. Whether at law or in equity. Now, what does that mean? Whether at law or in equity. I mean, you'd think it'd be really simple, wouldn't it? Co-ownership, we almost don't need a definition for it. Co-ownership means ownership, whether at law or in equity, in possession by two or more persons as joint tenants or tenants in common. So we know from that definition that you can be a co-owner as a joint tenant or a tenant in common. There was a third, but we don't worry about that. It's gone. But why does the law say that ownership, whether at law or in equity? Well, let's explore that a bit more. And that follows on, well, actually proceeds in terms of the definition of forms of co-ownership, which is section 33. And in section 33, it says, any property and any interest, whether legal or equitable, in any property may be held by two or more persons as joint tenants or tenants in common. I don't know why the definition clause for that division appears a little later. Actually, it is for division 2. So, it is at the start of that division. That makes sense then. Right, but again, we see these words, whether legal or equitable. A couple of things. The first is, when we talk about tenants in this context, it has nothing to do with leases or residential tenancies. Now, you've probably worked that out. But there is a little trap to this, certainly in Australia. If you're looking at the legislation now, or you're following this in a later session, just click on the link tenants as it appears in Australia, which you would think would take you to a definition, and it does. But following the link in the legislation in Australia will lead you into error in this case, because the word tenant is described in section 153. But note the drafting technique in section 153, that the section only applies to definitions in part 8, which deals with leases and tenancies, and in fact more particularly part 8 division 6, which deals with agricultural holdings. So where the system in this instance, and Australia is normally great, but just be careful, if you follow the link tenants to get a definition for tenants, it will take you to an entirely different meaning in a different context. So for our purposes, assume that the word tenants has nothing to do with leases or tenancies, oddly enough. It's just unfortunate that for whatever reason we have grown up using this word in two entirely different senses. I guess it traps people that aren't lawyers. Maybe that's a good thing for us as aspiring lawyers. Joint tenancy. Can anyone tell me how many unities there are? Nice, easy question. 4. Good. We've been doing our reading. A unity, 4, says Scott. Yep. So each joint tenant owns the entire interest in a property, both legally and beneficially. So we get that? It's a really odd concept, isn't it? It's as an owner, your interest is ubiquitous. It is everywhere in relation to the property. And the same applies to your fellow joint tenant, or tenants can have more than 2. When we talk about legal, we mean at law, which is pursuant to the common law. What do I mean by the term beneficial? When you see the word beneficial, what does that imply to you? I'll give you a hint. It's the contrast to the at law or common law. Equitable interest. Thank you, Leonie. So when you see the word beneficial in this context, and generally, think in terms of equitable interests. So a joint tenant owns the entire interest, legal and beneficial, but so does the other joint tenant. It's a really odd concept. Characterised by the 4 unities, time, title, interest and possession. With one other little thing thrown in. And I've mentioned it already. The 4 unities go with what other concept?
Right of survivorship.
Survivorship. Thank you, Scott. That's it. So when we're talking about joint tenancies, think about the 4 unities, time, title, interest and possession, and the right of survivorship or the rule of survivorship. Okay, so unity of time, the time of the title of the joint tenants must vest and be created at the same time. The title must come from the same document, the same act, which is unity of title. Unity of interest, same interest in the land, and possession, they're entitled to possess the whole of the land. And the right of survivorship prevents a deceased co-owner leaving his or her share by will to someone. So when you're taking instructions to draft a will, let's say a simple will for a person, would you explain that some things that they own cannot be left by them under their will? And if so, what would that be? We're getting some nods. So joint tenancy is an exception, absolutely. So there's a very real implication here, isn't there? Joint bank accounts, yeah, if it's held as joint tenancy. Superannuation's another, and life insurance proceeds are others that are generally not part of your estate. Now, that can often be, what we've talked about is the house and the super, the insurance money, and maybe the bank accounts. That's the bulk of what people own. So what point is there having a will if I really can't leave things that I own to someone else? So just keep that in mind. Tenancy in common is a little different conceptually in that even though there is a unity of possession and all tenants in common own the land and have the right to access all of the property, in other words, there is no physical division of the land itself, there is a difference, and that is that the tenants in common can at law own a discrete and specified interest in the property. The law of survivorship does not apply in a tenancy in common. So what if you're consulted by a person who says, I have just separated from my partner, we own property as joint tenants, I want to prepare a will, and I want to ensure that my share, if you like, is somehow protected. What's one thing that you could immediately consider recommending to your client? We will deal with it later in what we're dealing with tonight. Sever the joint tenancy. That's it. That was what I was looking for. Change to a tenancy in common. Thank you. And the way we do that is by severing the joint tenancy, which then by default leaves us with a tenancy in common. All right, so as you're reading the material, think in terms of the practical application of the work, and later we'll talk about a case where someone didn't, and it was costly. All right, so we have this interesting concept as seen in the legislation where we can have an interest at law and in equity. Well, we've done enough land law now to know this. Have we all done trusts and equity? Or have been no, we haven't. If you haven't done trusts and equity, it's a little bit harder to follow, but we've all done introduction to law. So we know that there's only equity. Trust is good too. So we know there's a difference between an interest at law and in equity. Does anyone want to tell me just briefly, simply, what the difference is in the context of ownership of land or an interest in land? So if you have a legal interest in land, what does that mean in practical terms? Registered, registerable title. Yes, I like that. Thank you, Nadine. Thank you, Leonie. Karen says, quite rightly, well, legal will take priority over equitable. Not sure about that, Karen. Maybe. What is equitable? Well, what's an example of an equitable interest in land? A trust, yes, as a beneficiary. Anything else? Other examples? A purchaser, a beneficiary under a will, a purchaser, says Leonie, an equitable mortgagee, an equitable lessee. So there are different equitable interests. Now, what we've noticed before settlement, purchaser before settlement. Right to acquire legal title, says Amanda. So some good answers coming in there. But you know, there's one common thing with all of those answers, isn't there? And that is that in every instance that I can recall that we've talked about in land law to date, the person having the legal interest is different to the person that we've described as having the equitable interest. In other words, in a sense, their interests compete with each other, one legal, one equitable. But now we're going to get into some theoretical territory where it becomes a bit ethereal. Where we have an interest in law and in equity, the same parties can have both. So, but as an introduction to that, let's talk about common law and equity in the context of co-ownership. Common law always favours or always has favoured a joint tenancy or a tenancy in common. What do you think? JT, joint tenancy. Excellent. Therefore, you'll have to be quick on your buzzers to get this one first. Equity favours what? Tenancy in common. Yep, thank you. There's no surprises for that one. In Queensland, what is the statutory approach? By statute in Queensland, do we favour tenancy in common or joint tenancy? TC. JT. We're getting different votes now. In Queensland, by statute, do we favour joint tenancy or tenancy in common? I'm still stuck at one vote each. Joint. Most of the votes coming in now for joint. The fact that I'm hesitating might suggest the opposite. Common. We'll get some votes for common now. All right. It favours tenancy in common. Have a look at Section 35. Section 35 reverses the common law presumption in favour of a joint tenancy. What that means is, by statute, in essence, if in doubt, equity prevails in the context of what we're talking about tonight. And if in doubt, a tenancy in common is the default position. So have a look at Section 35, and subsection 1 says, a disposition of the beneficial interest in property, whether with or without the legal interest, to two or more persons together beneficially, shall be construed as being tenancy in common, not joint tenants. Can I just say, if you're struggling with the Property Law Act, don't be necessarily concerned. I think it's, am I allowed to say this? I think it's dreadfully drafted. I would love to be on a law reform commission to redraft the Property Law Act. I think we could all do it much better. So if you struggle with the wording, don't worry. Anyway, let's just break down Section 35(1). A disposition of the beneficial interest, so that's the equitable interest, whether with or without the legal interest, that is the registered, what's on title, beneficially shall be construed as tenants in common, not joint tenants. Okay. But it doesn't apply in certain circumstances, and the provisions of the Partnership Act also come into play. Generally speaking, where we have, in a partnership situation, for partnership property, we have some special rules. A disposition of the legal interest to those who are joint tenants, and the beneficial interest as tenants in common. So it can override. Let's have a look at a case. This case is Woodgate against Tanks and Others, 2013 QSC 204. Now, in a will, the testator left this provision. As to the sum of $50,000 to each of Fran and Neil Hutton in equal shares as tenants in common. You'd think that would be fairly clear. You'd think it would mean they hold as as tenants in common. And that's in alignment with the presumption. However, the matter did go to court, and the court was asked to give a ruling on it. I'll read from the judgment, paragraphs 32 and 33. I do not accept counsel for the applicant's submission that there is inconsistency between the words to each of and the words as tenants in common and equal shares, nor do I accept that if there were such inconsistency, the words to each of should be treated as mere surplusage. In my view, there is no inconsistency if the words to each of are interpreted as signifying a plurality of recipients of one sum of money, and subsequent words are interpreted as signifying the nature of their co-ownership and their respective shares. Such interpretations would accord with one of the ordinary meanings of each and the presumption that the testator intended the expression tenants in common to have a technical meaning. Basically, the court declared on the proper construction of the will that it said and should be read as a gift of $50,000 to be shared by them as tenants in common in equal shares. What I'm really, I guess, getting at is this. When you read something in relation to joint tenancy and tenancies in common, please consider that the wording can be open to scrutiny, and it is possible that in those circumstances we may have a dispute. So don't assume necessarily it's as simple as it might seem at first instance. Have a look at section 36, which deals with tenants of in common of equitable interest acquiring the legal estate. So where two or more people entitled beneficially as tenants in common to an equitable estate become entitled in their own right, either as joint tenants or tenants in common to the legal estate in such property equal to and coextensive with such equitable interest, they shall be held by them as tenants in common unless the persons agree. So what that section tells me is, and it flows on from 35, that in certain circumstances it may be that at law people are nominated as joint tenants, but in fact in equity held to hold the property as tenants in common. Now it's getting a bit confusing. So by now at least we understand, of course, that it is possible to have legal and equitable interests in land. So we know that. These interests may exist simultaneously in the same piece of land, and I'm talking generally now, we know that. We know the legal interest is created by the law, and equitable interest is recognised by a court exercising equitable jurisdiction. So we know all that, don't we? That's all pretty basic. So to date, we've identified that different parties may have an interest in land that is either legal or equitable. That's the general situation. But here, what we've been discussing tonight so far is to answer this question: can the same parties with an interest in land simultaneously hold a legal interest and an equitable interest? And you would have noticed, yes, is the answer. Thank you. You would have noticed that it is possible to hold interests as co-owners differently at law and in equity for the same parcel of land by the same co-owners. So joint tenancies and tenancies in common can exist at law and in equity simultaneously. If that occurs, then almost certainly the situation would be that the parties own as joint tenants at law and tenants in common in equity. So it's now starting to seem a little less simple than it did within the first 5 minutes of what we discussed tonight. Sure, as a general rule, if you see that individuals are registered on the title as owning as joint tenants, then you can assume pretty much that they will own that property at law and subject to the rule of survivorship, with the general rules that joint tenancy applies. but you must always consider how equity would look at this, and it may make a difference in real terms. Given that, equity does assume or presumes a tenancy in common. And the thing about equity is this. Yes, sorry, Scott.
Just one question. You said there that you can, joint tenants and tenants in common can exist in law and equity simultaneously. You're talking about either or though, aren't you? Like joint tenants can't exist along with tenants in common at the same time over the same property, can they?
Well, they can, and this is where it gets weird. This is where it gets a bit freaky. But no, that's a really good question. I'm glad you stopped me there, Scott. So what I'm saying is that at law, when you look at the registered title and you see the parties A and B own as joint tenants, you'd think, well, that's all very simple. They own as joint tenants. There's nothing more to it. So I guess the lesson for tonight is to say, think about the equitable situation, think about the beneficial situation, think about what equity would presume, and think about what a court exercising equitable jurisdiction may wish to say about the equitable or beneficial ownership of that property as opposed to the legal ownership. So it is possible, I know this is all a bit silly, but it is possible for someone to own at law as joint tenants, and at the same time those same people in relation to the same property in equity hold as tenants in common. I mean, this is, if you like, my interpretation of it. As is typical with equity, it's as if to say, that's all very well, that's what it says on the title, but is that fair? That's really the kicker. Is that fair that they should be joint tenants? So the rules of equity generally do prevail. So it means that the right of ownership or the right of survivorship does not necessarily apply, even though they might be listed as joint tenants. And we do know, we've already established, that the right of survivorship does not apply when co-owners hold as tenants in common at law or in equity. So, when will equity presume a tenancy in common? Well, generally it does, but some specifics: if there's unequal contributions to a purchase price, if there's payment on mortgages or mortgagees, and if partnerships. That is, if the property is owned as an asset of the partnership. So in commercial situations, generally speaking, equity presumes a tenancy in common. Let's take a case. There's no answer to this, just something to think about. A and B purchase industrial land. They conduct a business for that premises for 10 years. And in acquiring the land originally, their conveyancer, perhaps through habit, registered the title as joint tenants. A passes on, and A's estate requests half the value of the asset, and B resists. So what's the legal position there? A and B are on the title as joint tenants. Does the law of survivorship, the right to survivorship, apply? What do you think? Or is there a maybe answer? The surviving partner B wants it, and A's estate says we want half share. In equity, is this a tenancy in common, or is it a joint tenancy in equity? Tenancy in common, tenancy in common, tenancy in common. Kathleen says could seek equitable jurisdiction, tenancy in common. We've come away in the last half an hour, haven't we? Like half an hour ago, we said, oh, look, if they're joint tenants, law of survivorship applies, simple. And now, half an hour later, we're saying, no, even though it says joint tenants, they're actually tenants in common. I wish we could make this simpler. To me, this is so overly complex, but it's the reality of the situation. So for a commercial situation, you need to bear in mind the presumption of equity. If the matter went to court, who bears the onus here? It's a bit of a trick question. Who do you think bears the onus? B or A's estate? Who's the one that has to prove something? The estate? One vote so far. The estate, 2 votes for the estate. The person wanting the 50%, yep. B, prove intention against the presumption. All right, so we've got a couple of votes for the A's estate, and we've got a vote for B's B. Well, I think it's fair to say that A's estate would be the applicant / plaintiff, but because of the equitable presumption of a tenancy in common, it will in reality be B that needs to establish evidence to argue against the imposition of that equitable presumption. I hope that makes sense. So even though A's estate will be making the claim, bringing the application, bringing it to the doorstep of the court, they will say, notwithstanding the existence of the joint tenancy, the equitable presumption applies, and that's what should apply in these circumstances without any further proof. Which means then it's going to be up to B, even though B is responding to the application or the plaint or the claim, to adduce evidence to overcome the presumption to win at law, to win in equity. So well done, Kathleen. Where would the case be litigated? What court? What's the court that deals with matters of dispute under the Property Law Act? Any thoughts? All right, so we're getting some votes. The Land and Environment Court, the Land Court, only 2 votes so far. Depends on the amount claimed. I think that's probably right. Look, generally speaking, the Supreme Court, we're getting a few votes now for the Supreme Court. I think the default position is the Supreme Court, but have a look at the specific pieces of legislation. For example, Section 329 of the Act says that the Supreme District Court have jurisdiction under Division 5 to make or revoke a declaration, but that's Division 5 for that part, and it even provides for some matters to be involved or litigated in the Magistrates Court. So generally the default position would be the Supreme Court. You'd think it would be the Land and Planning and Environment Court or Land Court, but it's not. And when you're reading the material, when you're reading the cases, take note of where the decision has occurred. So the cases I've read, referred you to tonight are all Supreme Court cases. Now, unequal contributions. Let's take this example. A transfers property to B. B makes no payment for it at all. If you've done equity and trusts, this might be a little easier than if you haven't. So there's a voluntary transfer of property. Now, the law presumes this was not a gift. There is an exception, and the exception is to do with advancement in where there's a domestic arrangement. The case that you probably need to consider is Calverley and Green, 1984, 155 CLR 242. The basic rule as per Gibbs CJ is where a person purchases property in the name of another or in the name of himself and another, it is presumed that the purchaser did not intend the other person to take beneficially. In the absence of evidence to rebut the presumption, there arises a resulting trust in favour of the purchaser, presumed resulting trust. Thank you, Leonie. Similarly, if a purchase money provided by two or more persons jointly, if the property is put in the name of only one, there's presumed to be a resulting trust in favour of the others. So even though we're dealing with land law, tonight we've been talking about the interjection and involvement of equity, so we do need to consider some equitable principles, some equitable cases. Keep Calverley and Green handy. But as we discussed in the context of the dispute between A's estate and B, a presumption is always something that can be reversed through evidence. It's a starting point. It's where we begin our discussion, that's all. But it does mean the burden of proof will shift, and in the earlier case I gave, it does shift to B. So Calverley and Green is authority for the further proposition that payments made after the initial acquisition can also trigger a presumption of resulting trust. So the rule in Calverley and Green is that equity presumes co-owners making unequal contributions to the purchase price hold as tenants in common, that is in equity, unless there's clear evidence to the contrary intent. And that's always subject to this presumption of advancement that applies in domestic relationships. You won't need to deal with that a lot in this unit, but you need to be aware of it. Okay, let's slightly modify the discussion to that process of registering co-ownership. What legislation do you think we'd look at if we're talking about the concept of registration of co-ownership on a title? LTA, the Land Titles Act. So we've been discussing the Property Law Act, but you do need to consider the Land Title Act, Section 56. So in registering an instrument, the registrar must note whether they hold as tenants in common or joint tenants. If the title does not show whether the buyers hold as tenants in common or joint tenants, which one prevails? Tenancy in common. Yep, consistent with the general rule. Case, it's in the notes, I think, is Malayan Credit against Jack Chia, MPH Limited, 1986 1AC 549. In that case, the parties leased a premises and the court leaned towards a tenancy in common, and part of the reason for that was that it was a commercial arrangement. Just another digression. I've talked tonight about this presumption of survivorship or the right to survivorship. What happens if you have a property jointly owned by 3 people and 2 of them die? Sorry, let's say, 2 of them die in a car accident. That's probably a bad example. We'll see if we can think of a different example. 2 people own joint property. Who dies first? We don't know. Is there a presumption about who dies first? Because both estates are saying we want the property, or at least we want half the property, if they died together. Oh, we're getting lots of votes. The oldest is presumed to have died first. Correct. What's the law that says that? Is it in the Property Law Act or is it in the Land Title Act? Oh, Karen's right onto this. Section 65 of the Succession Act. Thank you. So you can see already we've discussed 3 pieces of legislation as well as legal and equitable and some case law. Improvements. Again, there's a difference. Common law and equity. The right of a co-owner who spent money on improving or repairing co-owned property has certain rights that may differ at law and in equity. What about occupation? Are there differences there? I hope you don't mind me raising this, but I do like watching The Big Bang Theory. Has anyone seen that show? Has anyone watched it? No. Some yes, some no. All right. So a few have said yes. So look, there's one episode where Leonard and Sheldon have a fight, and Sheldon brings in Christopher Lloyd as a person to occupy his room. Has anyone seen that episode? Christopher Lloyd's great in that. I mean, the question is, if Leonard and Sheldon occupy this leased premises, and I think it's leased premises as joint tenants or even tenants in common, is he allowed to do that? Leaving aside, can Sheldon bring in somebody else to occupy his room? Don't worry about the Residential Tenancies Act, but I'm really looking at it purely from the perspective of the laws relating to joint tenancy and tenancy in common, bearing in mind, of course, that all co-owners have the right to possess and enjoy all of the property. So what do you think? Do you think Sheldon was entitled to bring in the Christopher Lloyd character to occupy his room? We're getting a few yes. Yes, I think he was. Because, and a couple of things there, an action of trespass can't be brought against a co-owner because he's entitled to the property, and co-owners can invite others to come and live on the property. Again, that's coloured by other more specific legislation. We've talked about resulting trusts tonight. Also consider constructive trusts. If you haven't done equity and trust, this is probably all a bit difficult, but a court may find the existence of a constructive trust, irrespective of the intention of the parties. That equitable remedy is flexible, it's discretionary, and it may mean that despite the intention of the parties, there is another avenue for declaring that the property interests be altered and in equity, notwithstanding that which is mentioned on the legal title. I did hope that this would be so simple and we could wrap it up in 3 minutes, but it's become more complex. And as I mentioned earlier, I don't think it needs to be this complex. Redrafted Property Law Act should resolve a lot of these issues. Now, okay, so let's see if we can come up with something concrete from tonight's discussion that will help you answer an exam question. Because we've got all these things that are flying around. All right, so here are the steps. Number 1, ask yourself, at law, how is the ownership reflected? So at law, this is the first question, is it a joint tenancy or a tenancy in common? Answer that, explain it. What do we mean by at law? What do we mean by registration? Talk about the Land Title Act. Number 2, note that there is a statutory presumption as to the existence of tenancy in common unless expressly stated to take as joint tenants. So bear in mind, this is only a presumption and it can be rebutted by evidence. So if the evidence is, yes, we purchased the property as joint tenants and that's what we intended, then that's a way of rebutting the presumption of it being tenancy in common. So I'm trying to make it clear that it's not that easy to overcome the existence of a joint tenancy, even though there's a presumption of a joint tenancy. So number 2, note the statutory presumption of a tenancy in common. Talk about it, talk about the exceptions, talk about the need for evidence. Step number 3, if the parties are joint tenants at law, consider whether these equitable principles in relation to the exceptions, and I've mentioned 3 exceptions tonight, might apply. The main one there would be in terms of a commercial partnership. And step number 4, if the parties are nominated as tenants in common at law, just make a note that equity follows the law and therefore they will hold as tenants in common in equity. So equity won't disturb that arrangement. If you follow those 4 basic steps, you won't go too far wrong. I hope that makes it a bit simpler. Severance. We talked about severance earlier. A few were able to identify it. Can anyone tell me if there is a legal process in Queensland which facilitates the process of severing a joint tenancy? I'll give you a hint. The answer is yes. But can anyone tell me where to find this statutory provision about severing a joint tenancy?
Land Title Act?
Land Title Act, absolutely. Sarah says, and you can get information about that from the Land Title Practice Manual. So it is indeed the Land Title Act. Thank you. Isn't it funny that all of the material that we've talked about in relation to joint tenancy and tenancy in common, well, most of it is in the Property Law Act, but when it comes to discussions about severing the joint tenancy, where did the Parliament decide to put it? Oh, we won't put it in the Property Law Act with everything else. We'll put it in the Land Title Act. Seemed a bit illogical to me. But Section 59 provides that a registered owner may unilaterally sever a joint tenancy by registration of a transfer executed by that registered owner. There is a requirement to give notice and a copy of the instrument to the co-owner, and that's an easy, effective way of severing the joint tenancy. Let's look at a case where things didn't go so well. It's called Smeaton and Others, that's S-M-E-A-T-O-N, and Others against Patterson. 2002 QSC 431. In that case, a testator retained a solicitor to prepare a will, leaving half the testator's interest in joint tenancies to his children. You can see a problem here already, can't you? Leaving some property owners' joint tenants to children. The solicitor failed to advise that to sever the joint tenancy under Section 59 of the Land Title Act, a transfer must be served on the other joint tenant. In that case, the court held, Justice Atkinson held, that, and at 39 said, on balance, I am satisfied that it is more likely than not that had Mr. Smeaton been correctly advised, he would have taken steps necessary to sever the joint tenancy and give effect to his testamentary intention. The court found the solicitor negligent and ordered that costs be against the solicitor in the sum of $256,000. Expensive mistake because you not aware of Section 59 of the Land Title Act. Possibly understandable if you go to the Property Law Act, you wouldn't necessarily think to go to the Land Title Act as well. Okay, another topic, and I know time is running on, so I'll try to move quickly. Ouster clauses, ouster conditions. So in making a domestic violence order, the court can make an ouster order, O-U-S-T-E-R. It is in fact not a separate order, but a condition attached to a domestic violence order. And it has the effect of forcing a co-owner to leave a home, even if they own as joint tenants. And if ordered to leave the home, the court can then allow that person to return with a police officer to collect their personal items. So even though we've talked about the four unities and the ability of a joint tenant to occupy the property, we've identified that we've got to consider the intervention of equity. We've got to consider the possibility of a severance of joint tenancy under the Land Title Act. We need to consider the possibility of an ouster condition under domestic violence legislation. Another thing that we need to consider is the possibility of the appointment of statutory trustees for sale of property held in co-ownership. We're back to the Property Law Act. Have a look at Section 38, and it provides that the court may, on application by co-owners, appoint trustees for the sale of the property, and there are certain obligations on the trustee to notify the parties, work with the parties, and in fact, if the court orders it, the parties can bid at the auction. Can anyone think of why you would possibly need to appoint trustees for sale of a property jointly owned or owned as tenants in common? Divorce, yep. Divorce, probably not so much, because the family court or the Federal Circuit Court would probably make an order to that effect. Bankruptcy, yes, bankruptcy may well be. Company partnership breaking down is another one as well. In general terms, it mostly applies where one party says, I don't want to sell, for whatever reason. That's when you might think about invoking this provision and making an application for appointment of statutory trustees. Just one case that I'll invite you to look at, and then we are very close to finishing. This is official trustee in bankruptcy against Cameron, 2008 QSC 89. In brief, Mrs. Cameron and her husband purchased and became registered as joint tenants a house in Kenmore. It was their family home. A few years later, quite a few years later, Mr. Cameron went bankrupt. He was discharged, but his interest in the property was transmitted to the official trustee in bankruptcy, which became registered as a tenant in common with Mrs. Cameron. Mrs. Cameron said, I don't want to sell. So the official trustee brought an application for the appointment of statutory trustees. Mrs. Cameron opposed the application, and she had some good reasons, the court said, to argue the toss. You would think that the application would be straightforward, but the point is that there are some bases upon which a court will refuse to appoint the trustees for sale. And it all goes back to that word in section 38 that the court may, on an application, appoint trustees for sale. I'll leave you to read the case if you want to know the details, but what I was really trying to just point out is that it won't necessarily happen automatically. Just to finalise, have a look at section 39 and section 40, which deal also with some of the specifics about the appointment of trustees for sale and the rights of co-owners to bid at sale if the court allows them to do so. All right, you've been very patient. Are there any questions, comments? We're all good? So tonight we've learnt that the examination is on, well, for almost everyone, I should think. Was it Friday the 12th of October at 2 p.m? And it's 3 hours. We've learnt that joint tenancy in common is not quite as simple as you'd think or maybe hope. And we've discussed some issues in relation to statutory trustees for sale. There's no session next week, so don't log on next week. It's the break, but we'll see you again in 2 weeks. Thank you for the excellent discussions. Yes, Karen?
But just to confirm what you said at the start, that when we do come back, you're swapping around week 6 and 7?
Thank you for that reminder. Yes. So when we meet in 2 weeks, I'll be talking about leases. And part of the reason for that is that I want to accelerate the discussion because it's so relevant to the assessment work. And so next time we meet will be week 7 material, and then we'll deal with week 6 material after that. So thank you for that reminder, Karen. Okay, have a good break, and we will see you in 2 weeks. Bye now.